Hey everybody, Mr. Moblin coming back at you again with another AP Gov video, focusing in again on topic 3.8, and this is taking a look at some aspects of due process. This time we're going to be taking a look at due process protections as it applies to circumstances dealing with the war on terror and the rights of the accused. Now, once again, last time we talked about, what due process is, and once again, as a reminder, due process is the series of steps and procedures that the government must follow if it wishes to legally deny you life, liberty, or property. Okay, and we talked about how that includes all sorts of various steps. Now, that being said, how is this going to be applied to some issues regarding from the fallout of 9/11? Now, we know on 9/11 that terrorists associated with the group Al Qaeda will be responsible for killing upwards of 3,000 Americans in a series of attacks. And in response to that, the federal government is going to try to make sure that something like this never happens again. And part of that process was passing the Patriot Act in 2002. And what the Patriot Act did is allow the government much broader authority to be able to search the records of people's phone calls and emails and stuff like that. Part of that included the ability to collect metadata from cell phones. And once again, if you don't remember what metadata is the basic information regarding who you called, when you called them, and how long you talked to them. It does not include, though, the actual contents of the conversations. But still, though, the question of, should the federal government be allowed to have that kind of information? There's information on there just from that some people might be embarrassed to have the government have access to, and they might not be doing anything, criminally. For example, like what if, somebody is, contacting a sports gambling place, you know what I mean? It's not illegal, but some people might be embarrassed or don't want other people knowing that they're doing that. So the question then becomes, is this legitimate information for the government to be able to have without a warrant? Well, we saw that an attempt to try to rein this in is going to be the passage of the USA Freedom Act in 2015 during the Obama administration, which is now going to require legal warrants to be issued in order for that metadata to be collected from somebody's cell phones. Now, there's got to be, a certain degree of reasonable suspicion / probable cause to get that warrant, but that is a required protection now per this law. Now, some other questions in light of the response to 9/11 and the subsequent war on terror, especially during the George W. Bush years, the first decade of the 21st century, includes questions, such as, hey, if we're fighting a group called Al Qaeda that we have not formally declared war on, through Congress, and is not actually a country, it doesn't have a flag, it doesn't have a government, it's not a sovereign state or anything like that, how do things like, for example, the Geneva Convention and aspects of the Bill of Rights apply? If you are fighting the nation of Japan in World War II, or if you're fighting Germany in World War II, just use the Germans for example. The Germans were the signers of, the Geneva Convention, and, therefore the United States was bound as a fellow signatory to follow rules regarding, the treatment of prisoners of war. But Al Qaeda is not a government. It has not signed the Geneva Conventions. So if we do apprehend people that we believe are suspected terrorists associated with Al Qaeda, do we have to treat them in the same manner? We've talked about, going back to the Eighth Amendment, questions of, can you waterboard these folks as a means to get information? But we still don't have, quite, answers about this. Are terrorist groups, people suspected of being parts of terrorist groups like this, as the government during the Bush years described as enemy combatants rather than prisoners of war, are they entitled to the same Geneva Convention protections? What if the United States engages in activities off of U.S. soil Does the Bill of Rights, does the Constitution apply? I mean, if you are, for example, detaining somebody in Afghanistan, back when we were in Afghanistan, does that apply? So, there's some very important and reasonable questions that go along with this. Now, we don't have all the answers to all these questions, but we do have some answers. And part of it includes habeas corpus rights. The Bush administration, early on in the War on Terror, was holding detainees, enemy combatants, without arraigning them in a court. In other words, they were just being held without, notification. They were not enjoying their habeas corpus rights. Now, the government is going to argue, the Bush administration is going to argue, that these are not citizens, and therefore they are not entitled to habeas corpus rights. However, these detainees were being held on U.S. soil at Guantanamo Bay in Cuba. And yes, a military base, as far as the Supreme Court is concerned, is U.S. soil. So the idea being is that if you're holding these folks on U.S. soil, regardless of their combat status, if they're an official soldier or a terrorist or whatever, they're still entitled to those habeas corpus rights. So they still have to be formally arraigned and charged in terms of, having a reason to, keep them in custody. Also, the Bush administration wanted to have these detainees that, are eventually charged with crimes, they wanted them to be tried in military courts. Now, the Supreme Court, overturned that. The Supreme Court ruled that no, you cannot use military courts for these individuals. These folks, technically are civilians, and therefore they're entitled to a civilian trial process. And yes, that would mean having to transport these folks off of a military base and into civilian life, which is something the Bush administration did not want to do. For public safety purposes, they wanted to hold these folks on military bases and have their trials on military bases, but the Supreme Court said that was not allowed. So, there's still a lot of questions that are hanging out there with regards to, how do we apply due process to folks that don't quite have citizenship status, they're not quite, POWs, what do we do with that kind of stuff? So interesting questions there. Now, shifting gears, taking a look at due process and focusing in on the rights of the accused here amongst civilians here in the United States. Now, one of these areas is included in the Fifth Amendment, and this is protection from self-incrimination. What this means is that people that are suspected of a crime or charged with crimes are not obligated to provide information to the government that would be used as evidence against them in a trial. The basic rule is that the burden of proof, in other words, the responsibility to prove guilt, is the government's responsibility, not the accused person's responsibility. So, if somebody has been accused of counterfeiting, it's the government's responsibility to prove the counterfeiting, not the person accused of doing the counterfeiting. Now, how does that fit in with Fifth Amendment protection from self-incrimination? Well, if you are questioned, or if you are on the witness stand in your trial, or in any kind of situation where you have to swear an oath to tell the truth, you still are not compelled to provide that evidence. So you might be thinking, well, okay, if I'm, been called to the witness stand and I'm the defendant and they ask me a question, that I have to answer truthfully, and that answer would be evidence used against me, and I can't lie, because if I lie, then that would be perjury. Well, then what do I do? Well, then you have the right to assert that you will not be answering that question, citing your Fifth Amendment rights, or as they much more commonly say, pleading the Fifth. So keep that in mind. Nobody is required to answer any questions from the government if there's any possibility that they think that what they say would incriminate them. Now, a lot of this protection is associated from the case of Escobedo v. Illinois in the 1960s, but it's now much more famously associated with the 1966 Miranda v. Arizona case. And you don't need to know Miranda by name, but the basic gist of this case is that Ernesto Miranda was an Arizona resident that was accused of kidnapping and raping a young woman. Now, when he was brought in for questioning, he was asked, a number of questions, and through the process of the interrogation, he did admit to the crimes that he was suspected of. Now, here's the thing, that testimony was then used, that confession was used as evidence against him to convict him. Now, following his conviction, he will file an appeal arguing that he didn't realize that he had a Fifth Amendment protection from self-incrimination, and that if he was made aware of that, he would not have provided that confession, and therefore the state would have had to have used other evidence to convict him. And in a very controversial ruling still to this day, the Supreme Court agreed with Ernesto Miranda. They said that a person's right to know that they have self-incrimination protection and a right to know that they have access to an attorney, these are such important rights that when a person is to be arrested, they are to be notified of this. And that is what's now become known as the Miranda rights. So when the police arrest you, they are required to let you know that you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. Do you have any questions? Do you understand these rights? They've been read to you. Now, note, the police don't have to say this immediately at the point of arrest, but it's in the police department's best interest to do so, because after that, you've been told, and now at that point, if you still want to provide evidence against yourself, that's your prerogative. You can do that, and it will be used against you. They told you that. But if you begin to extract information before that's been read, then what that information provides cannot be used against them. So the Miranda rights are very significant. Now, there are some exceptions that dealing with public safety issues. For example, if information is extracted while there's still a public safety concern happening in the moment, and they haven't been able to read Miranda rights yet, there's some exceptions for that. But generally, those rights have to be read to you. Now, the case that you do need to know by name for the AP test talks about due process rights regarding your Sixth Amendment right to counsel, in other words, the right to have an attorney. And this is centering in on the case of Clarence Gideon. Clarence Gideon was a drifter from Florida that had been in and out of jail many, many times. He was, barely literate, and he was suspected of breaking into a local pool hall and, stealing money from cigarette machine and the jukebox and yada, yada, yada. Now, when he was arrested and charged with the burglary, Mr. Gideon, given the fact that he didn't have any money, could not hire an attorney. And Florida law at that time did not require the state to provide an attorney. They interpreted the Sixth Amendment to mean that you just had the right to hire an attorney if you wanted to, that the government didn't have to give you one, though. Now, of course, Clarence Gideon, being, very poorly educated, had to defend himself against the state of Florida, which had actually an attorney. Well, as you can imagine, Clarence Gideon's not going to win this battle in court, and so he loses and sent to prison. But having learned, he actually does become much more educated on the law, looking at the Sixth Amendment right to counsel. He does file an appeal on the basis of, hey, how can I have a fair trial, which is guaranteed in the Sixth Amendment? How can I have a fair trial if I don't have access to an attorney? The idea being is, if the state has an attorney, the only way to have a fair fight is if the defendant also has an attorney. And the court agreed. The court agreed that the right to have an attorney is so essential to a fair trial, which we have the right to have, that the state must provide access to an attorney. Now, note, it has been interpreted to apply to felonies and major misdemeanors, things like that. If you have a traffic ticket, the Sixth Amendment right to counsel does not apply per se, in terms of the government having to provide that for you. And so understand that this is going to be a very important protection moving forward to guarantee this idea of a fair trial. Okay. All right. So that's some due process rights, focusing in on the war on terror and the rights of the accused. We'll see you next time. Bye-bye.